we can start over with our session. Before we start, I request everyone to kindly put yourself on mute. And in case you have any questions, we can take it up towards the end. So with that being said, firstly, a very warm welcome to everyone who's present here. Our session for today, like you all can already see on the screen, is about wealth management, where we talk about the different setups, which are basically trusts, foundation, and family offices in Hong Kong and UAE. So for Hong Kong and UAE, we have two speakers, two distinguished speakers who I have the pleasure of introducing. So we have Miss Christine Koo with us, who will be our first speaker of the day. Ms. Christine Koo is the principal partner of Christine M. Koo Solicitors and is based out of Hong Kong. She has over 30 years of experience in both government and private sectors there and also abroad. And her main specialization includes IPO works, acquisitions, mergers, investment funds, and insurance and trust matters. A very warm welcome, Ms. Christine. Our second speaker of the day is Mr. Naveen Indrakanti. He's one of the Asiajuris board members and has over 20 years of experience in advising clients and other corporates in varied matters and jurisdictions. His specializations include advising clients in mergers, acquisitions, and also setting up corporate structures and establishing trusts, foundations, etc. Mr. Naveen is also a STEP member and has been advising families across generations. So very warm welcome to the speakers and also our audience. And with that being said, I would pass over the mic and hand over the floor to Ms. Christine, who can start over with her session.
Thank you. Thank you, Sumaya. Shall we move ahead? Yes, today my topic is my favorite, the basic forms of trust. When we talk about the trust, let us understand the form first. So a simple trust usually have a few parties. You will have the trustee, and then the settlor, we call it the settlor or the grantor, depends on what you call it. It is either way, meaning the same person. And then of course the beneficiary. These three are the basic identifications. However, there are some protectors or governors or governing committee. Again, if you want, you can set up. A complicated one will have other parties involved as well. We will see when we move on. The next slide, please. Now, their relationship. When the main thing is to have a trust deed. So I put the trust deed in the middle. The trust deed meaning a document setting out the terms and conditions of the trust, which the trustee must comply with. And then the settlor sign together with the trustee, they sign the trust deed. In the trust deed, the beneficiaries' names sometimes are set out, sometimes they are not. And then the investment part of the trust fund will have to be delegated to an investment manager. Some of the trust, the investment function is delegated back to the settlor, but this can or cannot be done depend on the jurisdictions, depends on which jurisdictions it is. Okay, next paragraph, next slide. In Hong Kong, we have been a party to the Hague Convention. You know, the Hague Convention has actually got a section in its private law. It's got a section on the meaning of trust. So let us see the next slide. This is the Convention on the Applicable Law to Trust and their recognition. So Hague Convention actually recognized trust. And there is a definition in the Hague Convention about the trust. Let us move on. Next slide, please. So for the purpose of this convention, the term trust refers to the legal relationship created inter vivo or on death. So a trust is simply a relationship. It is created by a document intervival, well, when people are alive, so intervival, or upon death. The trust can be created when the settlor is alive, but can kick off after his death. It really depends on how the trust deed is drafted. And then the relationship created by a person, we call him the settlor. And when the asset had been placed under the trustee for the benefit of the beneficiary or for a specified purpose. Now, for the benefit of the beneficiary, we all understand it. Say, for the you set up a trust for the benefit of your son or your family. But what does it mean by for a specified purpose? Well, those charitable trust. If you have a charitable trust, you set it up for a specified purpose, or you may set it up for the purpose of paying all the hospital bills for my mother, for example, until he passes away, and then the money will be used for something else. So they can all be set out depending on what you want. Now, a trust has the following characteristics. It says the assets constitute a separate fund. The concept of a separate fund is important because when you set up a trust, the money is no longer yours. It is a separate set of money, and it is not part of the trustee's own estate. It doesn't belong to the trust. Well, it will be held in the name of the trustee, but it is not part of the trustee's own estate. So a trustee cannot mix up the two, cannot put the trust fund into his or her own account. It must set up a separate trust account to hold the fund. And the title to the trust asset stands in the name of the trustee. So if you have 10 millions, then the name of the account is held in the name of the trustee or some other name that is designated. But having said that, it doesn't belong to the trust. It doesn't belong to the trustee. It belongs to the trust, but not the trustee. Okay, so we have to get this idea clear first before a trust is really a trust. The trustee has the power and the duty, and he is accountable. Now you see how powerful the trustee is. He's got a lot of power. He can invest the money on behalf of the trust. He manages the money. So he is powerful, but then of course he is accountable. Let me give you an example of why he is accountable. There is this investment fund, the retirement fund in in England. In England, they have got a big union of miners. The miner, those miners who dig up the mines, the iron ore, the coal ore. The miners is a very powerful union. They have a retirement fund. Their retirement fund is held by a trustee. Of course, the trustee is a very big bank. And the trustee is responsible for investing the trust fund. Now, the trustee engage an investment manager. The investment manager somehow invests the money into a gold mine in South Africa. The gold mine in South Africa is making a lot of money. So the return of that investment is really good. However, in a certain year, around 20, 30 years ago, suddenly people talk about you cannot, the gold mine is an evil thing. One should not, there is this embargo of the South African gold. Let me put it this way. There was this embargo on South Africa. And so the gold mine, the price dropped tremendously. And therefore the the return of the trust fund, of the pension fund, dropped tremendously. So the minor decided to take action against the trustee, saying that, hey, look, you are vested with a duty to invest our fund or to look after the investment of our fund. You engage some stupid is my word, not their word, okay? You engage some stupid investment manager and make a loss of money. And you invest in some unethical product, which is the gold mine, the stock and shares of a gold mine. And therefore you must be accountable to the loss. And that case, actually, the rate union won that case. So you can see how trustees are in a vicarious position. I mean, in a very dangerous position. The trustee has a power and a duty in respect of which he is accountable to manage, to employ, or to dispose of the asset in accordance with the terms of the trust. And then there is this reservation by the said law of her right, of the rights to appoint, like for example, change the beneficiary, or change the trustee, change the investment manager. Next slide, please. Now, for a trustee, therefore, well, a trustee, we all know, is a very important person. It has to be, we have to treat it seriously. All the trustees in Hong Kong are licensed. Of course, you can have a single person being a trustee. If he does not carry it out as his business, then he doesn't need to be licensed. He is the trustee of only one trust. So you can create your own trust and then make your husband the trustee of the private trust. It doesn't need to be licensed. But if you want to have, if you want to be the trustee of various trusts, then you have to be licensed, and usually the banks and yeah, nowadays the banks. There are, of course, a lot of trust companies, but people starting to be scared because these trust companies, at the end of the day, they disappear together with your money. So we always use, I mean, we always advise our client to use banks as the trustee. Having said that, of course, the banks charges an arm and a leg. So I'll talk about it later, how much they charge usually. And then you have the trustee, you have the fund manager. The next one, the next slide, please. The use of the trust. Why do we want a trust? Usually is for succession purpose. For example, we have a very big development company here in Hong Kong. You must have heard it, the Chong Kong, Mr. Lee's family, for example. They have set up a trust already. And recently there is this case, the Kwok family in Hong Kong. They have a trust and it is for succession purpose. Why succession? Because the father set up a big development company. It is multi-billion-dollar publicly listed developer. Now, if he has got 3 sons, if he divided the shares among the 3 sons, then he is afraid that one of the sons might sell the shares to some other person who's got ulterior motive of controlling his company. You know, all you need is 26% or 25.1% to control a listed company. So that's why they are very skeptical. They want the company to be controlled by the same family for as long as possible. So they set up a trust, making the mother, the father was the settlor, he now passed away. The mother and his best friends are the governors of the trust. But of course, subsequently, there was this big, huge litigation between the eldest son and the mother and the trustee of the trust, but that's another story. This is asset protection. There is other usage, for example, asset protection of divorce. Upon the divorce, there is this, again, this real life story. Another rich man, his son married a movie star. And the movie star, after giving birth to 2 sons, wanted a divorce because the husband is doing naughty things. And the daughter-in-law, the movie star, said, I want how many billions? And the husband said, look, I don't have any money. All my money came from the trust fund. You can have part of my monthly allowance from the trust fund, but that's all. You cannot have the capital because the capital were all controlled by the trust. The movie star doesn't believe him, and they discovered, we call discovery, right? In law, we call discovery. They asked the judge to call for the document, and the judge actually finally asked the father of the son to come to court to give evidence, to say the trust was set up, how much the son was given a month. So at the end of the day, the movie star cannot get billions. Instead, she got, of course, she got sufficient money, monthly allowances to enable her and her son to survive. So you protect your business empire. The third use is to avoid probate. I mean, people got a lot of properties everywhere. For example, Kim Tong, are you there? So I understand that you have a property in the Himalayas, have you not?
I'm here, I'm enjoying your presentation, it's just really good.
My stories. Hey, so your Himalaya, you've got a property in Himalaya, you've got a property in US, you've got a property in, I don't know, Canada, Australia. Now, just think of the probate. Our firm has done the probate for over 10 years because the Chinese gentleman who died, got property, actually, this is the actual case in Hong Kong, Canada, and Brazil. Believe it or not, he's got a property in Brazil. So when you do the probate, you have to do it a country by a country, right? Step by step. So it takes 10 years to really clear up in the multi-jurisdiction. The next use will be to avoid the estate duty and the stamp duty. Now, before, well, I think 20 years ago, Hong Kong has got estate duty. These days, I understand, I'm not familiar with the US law, but I understand that in US, a lot of properties were bought in the name of a trust so as to avoid estate duty. Tell me if it's true or not, all right? Anyone who knows about US law. So, but of course, when you talk about, once you talk about tax, it is very sensitive. It involves AML. You've got to do a lot of due diligence, make sure it is not money laundering, it is not tax avoidance, it is not this and that, and you ensure your client will not be challenged by the tax department. The other thing we talk about will be confidentiality. So Kam Tong is telling everybody he's very poor, but in fact, all his money were in the trust. And then his children, his grandchildren were all trust babies. We call them trust babies because these trust babies will get money every month from the fund and they lived a more than comfortable life. But then you see all the properties they reside in, like 10 million US, the property costs 10 million US, but then it's not in the name of the son. It is in the name of the trust. And the trust just permits, allows the son to stay there rent-free, and then for as long as he wants, until he's tired of it, he can change it. but he cannot sort of own it or sell it. He cannot sell it. This is a good point to, I was told by my lecturer when I was doing law in the universities of Hong Kong. They asked us how the trust came about. And it first came about, of course, there are different stories, but then they said in England, it is very popular because all the manor, the castles with acres and acres of land were all held in trust. And I went to London quite often before the COVID. And actually there was this story about, have you seen the movie called Downton? What was that movie called? Just escaped me, but then you know what I mean. All those castles were all held by the trust, and it is difficult to sell these castles. So a lot of these castles were left unattended now when the economy turns down. The most sensitive thing is when they say you can avoid the risk, the political risks. Actually, in Hong Kong, there was this story. Before 1997, there was this case, somebody, a very multimillionaire again, set up a trust. And the Inland Revenue Department challenged the trust, saying that, hey, look, this is not a genuine trust. This is not for the protection of asset, but this is for the avoidance of estate duty. Because about 20 years ago, Hong Kong still have estate duty. So if he needs to pay the estate duty, he needs to pay about 20% of his all the assets, which comes to around over 100 million, 200 million, I don't know how many millions. And there was this case, they appeal, and finally they say, look, this is not an avoidance scheme. The idea was not to avoid the estate duty. The idea was to protect the asset against political risk. Why political risk? Because at that time, Hong Kong is going through this change hand from one sovereignty to another sovereignty. And in the change, you do not know whether all this assets can be continued in the same ownership. So they change hand. But of course, now it sounds ridiculous and nobody will believe it. But then at that time, even the judge believes the story. So they say, okay, so this is a genuine purpose trust. You can have it and you don't need to pay any estate duty. So there you are. It really depends on the judge at the time. Next slide, please. Now, the trusts that I mentioned are all personal, individual trusts. Now we talk about those trusts for retirement scheme, for example, for commercial use. The retirement scheme in Hong Kong, we call it Mandatory Provident Fund Scheme, MPF. They are all trust-based. And the real estate investment trust, also they are trust-based. Have you got real estate investment trust in other jurisdictions? In Hong Kong, this is quite popular. It is also popular in US, popular in China. What the real estate investment trust talks about is that the trust own a lot of commercial buildings, those high-end commercial buildings. So it got a lot of rental incomes every month, right? And the trust set up collecting all these incomes and distribute them in the form of a unit. So they are in the form of unit trusts. And then they are listed. It can be buy and sell in the market, in the exchange, stock exchange. So it is a kind of investment vehicle. Trust is a kind of investment vehicle. And of course, we've got other equity investment schemes, like you buy all the shares and then you divide them into units and turn them into unit trusts and then sell them. These days, we've got family office. Family office is such a popular name and a very sexy name, but then is basically just a trust. Next slide, please. Now, licensed trustee, the banks. Again, I have to emphasize, because we have seen too many trust companies which are a bit scary, because the trust company might disappear. But for banks, particularly those big banks, they won't. I mean, if they disappear, they probably disappear with your savings as well in the bank, so they won't. However, when people trying to spread the idea of a trust, they use private trustees. So they set up BVI companies. The question is, who is the shareholder of the BVI company? Now, if the settlor is the shareholder himself, in US, I was told it can be done. It can be done. The trustee and the settlor can be the same person, but then in Hong Kong, probably not. We will call it a sham trust. We are very much common law based, and the trust has to be a genuine trust, not a sham. Next slide, please. Oh, is that all? Is that, I should have some other, let me check my PowerPoint. I should have another one talking about the fees of the trust. To set up a trust, it involves two things. One is the legal cost, that is, you have to pay Christine Koo your arm and a leg. No, I'm just kidding. The trust, because it's standard form, is not expensive, but you have to pay quite a lot monthly management fee to the trustee. It actually depends on how large the estate and how much work that you need the trustee to do. Give you an example. This is my last story of today, and it is also a genuine case. There is this movie star, you all know her, Anita Mui. Do you know Anita Mui? Kem Tong, have you heard of Anita Mui? The Canton Pop, the singer, right?
I love her. I love her.
Everybody loves her.
I feel sorry for her.
Yeah, unfortunately, she passed away, but she left a trust.
Yeah.
She left a trust with Hong Kong Bank as the trustee, so all's well. But then you see, the mother was so unhappy with the trust. She kept on challenging. She kept on challenging the power of the trustee, saying that, hey, you should give me more money. Hey, you should not give the money to her friend. You should give that money to me, that sort of thing. And because of that, the trustee need to spend a lot of money from the trust fund that she settled into the trust to do the litigation, to defend the position of the trustee. So when there's a litigation case, the trustee defend the trust, the money comes from the trust fund. When there's penalty, the money comes from the trust fund. When there is investment lost, the money comes from the trust fund. And plus the monthly management fee. Now, the monthly management fee is a percentage of the total amount of the trust fund, with a minimum amount. A minimum amount, probably you are looking at a few, not a few $1,000s, a few tens of thousands of dollars a month, plus other works. So I'm afraid before long that trust fund has to be wound up because the trust
Right.
spends so much money on litigation. Not that they want, it's not the fault of the HSBC, I must say, but somebody was trying to sue the trust fund, the trustee. So the good thing about a trust, we've talked about it, and the bad thing, so you have to really be as rich as Kem Tong before you can set up some trust. So thank you very much. That's the end of my presentation.
Thank you so much, Christine, for your presentation. And I think when I say this on behalf of everyone. Your examples and your anecdotes are really interesting. So we really had fun listening to it. So thank you so much once again. And now we move on to our second speaker for the day, Mr. Naveen Indrakanti. The floor is now open to you.
Yeah, thanks, Christine. It was really informative, and as well as not only fun, it was very informative also. Thank you very much for the presentation you gave. So today, the topic, as you all know, it's going to be wealth management. So what is a wealth management? Just I say in a short, wealth management is, first of all, you are supposed to have a wealth, like a Campton. Christine said, you are supposed to have a lot of wealth like Campton has. So then you need a professionals who can manage the wealth. So how they do is it's a wealth management is a kind of a creation of a wealth, protection of the wealth, management and protection. So these are three important. So not having a wealth itself is not enough. You are supposed to increase that wealth, whatever you have, by doing proper investments and proper structuring. And also you have to protect it by doing proper structuring. And also you have to manage in between protection and creation of the wealth. So these are the three main ingredients for the wealth management. And you need various professionals involved in various stages of this. Generally, individual or a group of individuals, they create a wealth, and you need a professionals who will advise you on how to do a proper investments. And there are certain professionals who advise you how to manage that investments, and there are professionals who advise you how to protect that wealth that you made. So these are all the various things that are involved in wealth management, which we are going to discuss how we can do, what are the aspects. We are not going to speak about how to create the wealth. We may not be speaking about how to manage the wealth. Only two aspects we are going to concentrate today, that is how to manage it and how to protect it. Okay, next slide please. So what are the modes of wealth management? So you can, as Christine is from Hong Kong, which is a common law jurisdiction, she has stressed a lot on the trust. So now I'm going to give, because I'm into kind of a hybrid jurisdiction. We follow civil law, we follow common law, we have all kinds of Sharia law. So we have all kinds of laws that we follow in this country. So I'm going to give various examples on various things. How can you do the wealth management? So those are kind of a foundations, trusts, and family offices. These are the main basic structures or basic models through which you can do the wealth management. Next slide, please. The foundations. So the foundation trust, as Christine said about the trust is a common law concept, whereas a foundation is a civil law concept. So as Christine already said that trusts are origined in the UK, in England. Yes, exactly it's same. So the trusts are origined in the UK. During that crusades time, the people, whenever they go for crusades, they used to come all the way to the Middle East, and they used to leave their wealth to people to take care of as a trust. And that was in 1546. It was kind of legalized, and the rules were framed by the UK courts, and then it's followed onwards. That's a trust concept. Whereas the foundation is basically, they are a continental Europe or Roman law countries that they follow the foundation. So the origin happened in German-speaking parts of the Europe, and now almost all continental Europe, they follow the foundations. The trust is alien things to them, as similarly the trust is alien to the common law countries. Foundation is alien to common law countries. So in the foundation is basically a company without a shareholder. So the foundation structure operates like a company operates. It will, instead of a board of director, you will have a council members here. Instead of you will have a founder. The founder is like a donor or a settler. It's the founder. So the founder will find a trust, and it will have a board of directors. In the place of board of directors, you call them foundation council members. So it will have a council members who will manage day-to-day affairs of the foundation. So the foundation will not have a shareholders, but it will have a beneficiaries. So beneficiaries are not owners under the foundation, but the beneficiaries are only beneficiaries. That means there are no owners. That means there are no shareholders. So if you keep founder donates his or her assets to the foundation, then the assets belongs to the foundation, because foundation is a legal entity. Unlike a trust may not be a legal entity in a strict sense, but it is a legal arrangement. Whereas a foundation is a legal juristic person like a company, and it operates by bylaws. So similar to trust deed, you will have a bylaws. Bylaws are like a memorandum of articles of a company where you have. For a foundation, you will have a bylaws, and bylaws will describe, these bylaws will describe how the foundation council has to act, and what is the purpose of the foundation, and how the foundation money has to be used, how the foundation wealth has to be managed, and all those things will be there in the bylaws. And also a constitution basically a framework under the statute, whereas the bylaws are tailor-made for each foundation by the founder and the council member together. And the council members are cannot change the bylaws. They have to follow the bylaws to the strict sense. And as you said, a sham thing or it's a genuine foundation will always to the subject of discretion. If this founder has a more role to play in the day-to-day affairs, then it's obviously considered as a closely controlled foundation, and it considered as a sham and tax purpose. You cannot take any benefit. Whereas the foundation is a kind of a discretionary foundation where this founder has a little scope in controlling the foundation, then it's considered as a genuine and discretionary foundation, whereas it has a lot of benefits. If you go to Europe, you'll find a lot of companies, and especially the Rolex and all these are all foundations, which are family foundations founded a long time back. Next slide, please. So now we'll come to the jurisdiction where I am. What are the foundations and how it works within the UAE? You have to consider in the UAE, the foundations can be made in 3 jurisdictions. Right now, initially it was only 2. That is the Dubai International Financial Center and ADGM. Now the DMCC is also going to allow soonly to do certain funds, but it is not completely there. So now you have a jurisdictions, but DIFC and ADGM, they are also common law jurisdictions. But and Ras Al Khaimah is also one of the jurisdiction where you can make a foundation. So Ras Al Khaimah, DIFC in Dubai, and ADGM in Abu Dhabi, these are the 3 places where you can make foundations. And these all 3 jurisdictions have their charters or else constitutions already prescribed, and within that charter you can make a foundation on the bylaws basing on that. Next slide, please. So these are the three jurisdictions where you can do. And as I said in previously, the foundation is an independent legal entity, and as such, once you donate your assets, founder donates assets to the foundation, you have to remember one thing: it's not only the founder. The founder can be only one person, but donors can be many. So that means I found a foundation, I formed a foundation, and I am the founder, and I donated my assets. And my children also have assets. They can also donate their assets to the foundation, and it will become the foundation assets. So there is no obligation that only the founder has to donate the assets. Anybody can donate assets to the foundation, and they will become foundation assets. But the bylaws can be done only by the founder, not by the other donors. So the bylaws can be done by the first the founder, but not by the donor. So the donors can only donate, but they cannot change the bylaws. And another thing is that in the foundation, the thing is that the bylaws can be changed during the lifetime of the founder. A founder can change the bylaws during his or her lifetime, but once the founder is no more, then the bylaws cannot be changed anymore. Then the final bylaws, what are left with the foundation council, is the letter on, they have to follow to the letter, whatever the bylaw says. Then the next slide, please. So the founder, so minimum one founder is required, which can be an individual or legal entity. So even a corporation can also be a founder, can also form a foundation. Typically, founder has no more rights toward the foundation. However, the bylaws can be drafted and also can be changed during the lifetime of the founder. And you have to take it one something into consideration. The founder is too much interfering into the foundation activities, then it will be considered as a sham foundation and it will not give any benefits that a foundation may have, because most of the times the foundations are made for certain purposes like avoidance of inheritance tax, because there are nobody is succeeding to the property, but it's going to be, there are going to be beneficiaries who will have certain benefits that are described as a monthly or yearly benefits, and those benefits will be subject to the tax, but not the foundation assets, depending upon the jurisdictions where you are. The next slide, please. So the council members. So there are minimum 2 council members required to act as a council members in the foundations. These council members are also be considered are similar to the directors of a company, but they are called as a council members, and the day-to-day affairs of this foundation will be taken care of by these council members. And any voting will be done, and generally that's why we always do 2 or minimum required, but better to have a 3 foundation for council members. So in the event of any disputes with regard to how to manage the foundation assets, whether the bylaws are clearly followed or not, that then a majority can take a decision, something like that. However, beneficiary can always challenge the activities of the council members. But you have to remember one thing: under the foundation constitution anywhere in the world, if any beneficiary challenges the existence of the foundation, then automatically he will not become a beneficiary. So that means he will be removed as a beneficiary. You can challenge the activities or acts done by the council members, but not the foundation itself. So that means my father created a foundation, then and I go say that no, there is no foundation, the foundation is illegal, issue, the creation of the foundation illegal. Then if I'm a beneficiary in the foundation, then I'll be debarred to be a beneficiary and my name will be removed as a beneficiary. So you have to keep in mind. So only acts of the council member can be challenged by the beneficiary, but not the existence of the foundation. Next slide, please. So we call them guardian or a protector, whatever the name you call them, you can have one. So these persons will have a certain rights, and they are generally appointed to supervise the acts of the council member, and it can be an individual or else it can also be a corporate. So if you feel that it's a foundation is for a longer extent, obviously you wants to have a foundation forever, because you can put all your companies, all your operations under that, and you want them to be forever because it's our legacy. So then you obviously will choose not an individual. Mostly you will choose a corporate entity as a protector, and this protector will also supervise or else sometimes guide the foundation council how to implement the bylaws. And you have to consider, and these protectors or guardians are also considered as ultimate beneficial owners as the founder, in similar line to the founder, because they also have the activity in controlling the acts of the foundation. Next slide, please. So registered agent, as per the Russell Khema ROC ICC rules and regulations, you are supposed to have a registered agent who will register a foundation with ROC ICC, and they are the people who are supposed to be responsible for the keeping the company in good, the foundation in good standing. That means they don't interfere in the operations of the foundation, but they are only kind of administrator to keep the foundation in a good standing. So that renewal of the foundations, foundation is like a company, so that means it has to be renewed every year. Okay, so those renewals and everything will be done by this registered agent. So you need a registered agent under ROC ICC guidelines and regulations. Next slide, please. So beneficiaries. So every foundation, as I said, will have a beneficiaries. They are also called as a qualified recipients, and they will be having certain benefits prescribed under the bylaws in the foundation. And as per that bylaws, they will be receiving whatever they are supposed to receive from the foundation. And this beneficiary can be an individual or a group or of an entity. So that means there is no need to make an individual or else physical person as a beneficiary, but you can make an entity or as a corporation also as a beneficiary, which can benefit from these foundations. So these are all no right or interest in respect of the foundation other than the right of payment. So that means the beneficiaries has no role in controlling the activities of the foundation except receiving the benefits that are prescribed under the foundation. So their role in management of the foundation is nothing. Next slide, please. So you are also supposed to have a registered office and Russell Kema. All they are supposed to have a registered office because it's being considered as an illegal entity. You are supposed to have a registered office, and whereas there is no obligation that council members should be sitting in the registered office. Council member can be anywhere in the globe. They will not. There is no need for them to sit in the registered office, but you need a registered office for the purpose of correspondence, and the council member can operate remotely from wherever they are. Next, please. Next slide, please. So what are the governing documents? They are charter and bylaws. Charter is like a constitution, and bylaws are the articles which you make made by the founder for the running of the foundation. The founder can include the following control mechanism in the constitution of the documents, like appointment, removal of council members, and her capacity as a founder. In her capacity, in her or his capacity as a founder, they can also prescribe a mechanism how the council members can be appointed and how the council members can be removed, how the council members can be changed, and how the council members can be debarred to act from as a council members for certain violations. All those things can be prescribed in the charter and bylaws. And the powers of the council member also can be restricted and can be prescribed in the management of the foundation. And also supervisory veto rights as a guardian. That means a guardian or a protector, whoever is appointed to protect the foundation, so that it operates as per the wish and as per the according to the bylaws, can also be given a veto right to veto the council members' decision. Similarly, reserved powers to amend the constitution can also be under termination of the foundation can also be given under the foundation. That means there is no need for the foundation to run forever. So in the bylaws, you can prescribe when the foundation can be closed down, because you have to remember one thing: for a trust, as per the latest judgment of the UK courts, a trust can be wound up by the majority beneficiary, by the all the beneficiaries under the trust decides to wind up a trust. It can be done so. Whereas the foundation, it cannot be wound up unless there is no assets to manage the foundation, or else a mechanism is prescribed in the foundation how it can be wound up. Or yes, next slide, please. What are the advantages of the foundation? As I said, the foundation is being a legal entity. It operates as a corporate. So it doesn't involve, it doesn't require it to be closed down. It can operate to forever, for whatever time the founder wants to have. And you can also have the flexibility, and because certain tax savings purposes, and also the distribution of wealth, and various things can be considered in that, so that flexibility is there with regard to the change of the bylaws and all those things. And also is a succession plan or inheritance, so you can use the foundation for succession plan or inheritance. And the wealth asset or protection, because as I said, once you donate the property to the foundation, the property becomes the foundation's property. And if it's a discretionary foundation where the founder's role is limited, so then this is considered as a independent asset of the foundation. And as such, if the founder or any beneficiaries are subjected to any legal requirements or any legal obligations or any loans, then those creditors cannot go against assets of the foundation, but accept the benefits that the beneficiaries may receive. So that means in large, the foundation assets are secured, and it cannot be secured from the third party creditors, and no third party creditors can challenge the foundation to go against the debts of the founder or anybody, except the founder has created a foundation with the intention to defraud the debtors. That means there are already debts are there, and he puts a wealth in his foundation just to defeat the claim of these creditors. Then the foundation can be challenged. Otherwise, the debts, there are found assets already in the foundation, but the debts are future accrued debts that is subsequent to the creation of the foundation. Then these creditors to whom the founder is liable has supposed to pay only from his personal wealth, but not from the wealth of the foundation. So that way, your asset is very much asset and wealth are very much protected in the foundation. Next slide, please. So as further advantages are the tax benefits, and you can also create a foundation for charitable or philanthropic purposes. And also you can have a corporation or a foundation to manage employee-based programs such as pensions or remittance plans, etc. So these are all other advantages. Next slide, please. So I said there is a DIFC, Dubai International Financial Center, which is in Dubai, can create a foundation. There is a ADGM, Abu Dhabi Global Market, which is in Abu Dhabi, also can create a foundation. Ras Al Khaimah, International Council of Chambers, ROC ICC, that also can, international companies that also can create a foundation, ROC ICC. So what are the difference between these three? The DIFC regime is only regime which allows a company to be morphed into foundation. That means if you are already having a company, the DIFC allows you to change the existing company into a foundation. Whereas in ADGM or ROC ICC, you have to form a foundation, a fresh foundation, but existing company cannot be changed into a foundation. But you can link an existing company under a foundation, but cannot convert or morph it into a foundation. And in DIFC, permitted to have an exclusive charitable purpose, whereas ADGM may not have a guardian or a protector. Is a mandatory for a charitable purpose foundations in ADGM. Whereas in DIFC, you can have an exclusive charitable foundation, but whereas in ADGM, unless you have a protector, they may not allow you to have a charitable purpose foundation. So all these for foundations, one more thing is that you have to keep, they have arbitration as alternative dispute resolution format. So you can prescribe arbitration as a dispute resolution within the charter of this foundation charters. Finally, DIFC Foundation is able to issue a depository certificate, that is a securities, representing value of the contributed assets from the contributor and their entitlement to the same. So you can also have a securities or a deposit certificate in the case of DIFC in the formation of foundation there. Next slide, please. Now we'll come to ADGM. ADGM, the ADGM, the identity of the council members is kept confidential in the ADGM, whereas in DFC, the information is publicly available. So that means council members' names are not disclosed in ADGM foundation. So that means any foundation will be shown, but will not be shown publicly who are the council members who are managing the foundation. Whereas in DAFC, the information of the council members are publicly available in domain, like you get for any other directors of any other company, you get for them also in DAFC. The ADGM Foundation regime is the only one with the no ongoing annual requirement to file audit accounts unless requested by the registrar. So there is no requirement for a foundation to file annual returns in ADGM foundations unless the registrar requests, if he suspects something is going on in a foundation, then he may ask for the annual returns to be submitted to the registrar. Otherwise, there is no obligation on the foundation to file annual returns with the registrar. Accounts record must be properly maintained as per the other regime, however, not required to be filed unless requested. As I said, you have to maintain the records, but it will be in the registered office of the foundation, but there is no with the agent. Registered office can be the office of the agent, so it can be kept with the agent, but there is no obligation to file it with any authority unless it requested to do so. So whereas, as I said previously, ADGM philanthropic foundations, they have certain restrictions, as you must need a protector. Otherwise, you cannot create a foundation for philanthropic purposes without a protector or a guardian. Next slide, please. Thus, RAC ICC need not maintain a publicly accessible register of information in relation to the foundation. So that means once you create a foundation, no public record is required to be maintained. So that means it's completely discretion of the authorities to disclose only whenever there is a legal requirement to be disclosed. They may disclose this information with them under the OCS or else under AML guidelines, but there is no record is available. So nobody can see what are the foundations existing there, who are the beneficiaries, who are the founders, who are the council members. This information is completely not available anywhere. So this for certain people who don't want their names to be appeared as they have created a multi-billion dollar or multi-billion dollar euros dirhams foundations. They can choose this one because their identity is not revealed anywhere. Now nobody knows such foundation is existing. Information related to the foundation will not be disclosed unless required by relevant authorities, as I said, under OCS or else AML requirements. Registered agent is a mandatory requirement, whereas with the DFE regime, it is only optional. So as I said before, the registered agent is mandatory with the RAC ICC, whereas in DFC and ADGM, it is not mandatory, but it's only optional. The advantage of having a registered agent is sometimes you can have an address for communication, and because you have to understand one thing, in other places, the council member addresses are disclosed in DIFC. But a council member details are there with the ADGM, whereas in Russell Khaimah, RAC ICC, the information is nowhere available. So they need a address for communication. They need a party to be contacted regularly. As such, they need a registered agent. And also they need a registered agent for the purpose of renewal of these foundations, because they don't want to run behind everybody. They know a place where to go. Whenever the foundation is not renewed, they know where to send the notice, where to send the information. So for these operational requirements, they prescribes an agent, a registered agent to be there for a foundation in RAC ICC. Next slide, please. Now we'll come to the trusts. So here you have to understand that the trusts also a similar thing, and you can create a trust in 3 jurisdictions, which I said previously. You can have a trust in DAFC, you can have a trust in RAC, you can have a trust in ADGM. So all these three jurisdictions allows you to have a trust. So the trust is not a distinct legal entity, but it is a legal arrangement between a trustees and the settlor. So in the trust, hold assets as a trust for the benefit of specified benefit of the specified persons for specified object who are called as a beneficiary, and objects will be disclosed or described or stipulated in the trust deed. So like a bylaws for a foundation, in a trust, you will have a trust deed which specifies what are the objects of this particular trust and how the disbursement has to be made, how the assets has to be managed. All these things you can describe in the trust deed. A trust structure, as I said, is a legally binding arrangement between the trustees and the settlor. Settlor. Yes, please. Next. So UAE has a federal law number 19 of 2020. They formed a trust law. So as per this federal law means Dubai is a federation. Each emirate will have their own law so for all purposes, and this emirates law can be superseded by the federal law. So that means whatever the laws are there, federal laws, there is a dispute between the any laws of the emirate and the federal law, the laws of the federation will prevail over the laws of the emirate. So this federal law applies similarly to all the emirates. So as per this trust laws, federal trust laws, a settlor is agreeable to assert a trust over property that they own. So that means you cannot create a trust for a property which you don't own. Similarly, they are supposed to have a beneficiaries, trustees to direct and govern the trust, property that is recognizable and a matter of trust, trust proceedings in written form or legal documentations, registration of the trust in the new UAE trust register. So these are all the requirements under the new trust law. So next slide, please. And also they prescribed what are the obligation of the trustees. The trustees are obligated to manage, direct, and control the trust property. If trust property is restricted by trust terms or by a court, the trustees cannot override these limitations. To govern all the handling of trust property, to implement required proceedings by execution of control, authority, and responsibility, to protect the trust property by all means. So these are all various guidelines that has been prescribed under the federal law, which controls, restricts, and also makes sure that the trustees operate within the laws in a proper way as per the statute. Next slide, please. So now we'll come to the family offices. So we already discussed about the foundations and trust. So family offices are a single family offices, what we call is a new concept that is starting nowadays. It is there for it was there, but mostly it was not as a corporate structure, but it is a generally certain individuals handling certain assets. But now it's taken into more robust form, and now there are more various jurisdictions are coming up, various regulations and various formalities how this single family offices can be regulated or controlled and operated. So we'll come to that. Next, please. So the single family offices are right now you can have a family office as a family office registered entity. You can have in DAFC, you can have a ADGM, you can have a RACICC, and you can also have a DMCC. So Dubai multi-commodity zone is also came up with the concept of family offices, because most of these DMCC is prescribed for precious metals, and as such there are various entities, various individuals who operate precious metals. So they introduced this DMCC family offices, where you can have a family office also there registered there. So this the single family office must be owned at 100% and shall only have regard to the proceedings of 3 direct generations of living member of a family in question at the time of the application. So that means if you are applying for a family office license with any of the entity, any of these uh, any of these regulatory authorities, so then you can are supposed to apply as a licensed person, as 100% licensed owner, and you are supposed to apply for a license to manage assets of 3 generations of a family. So not beyond that. You have to keep it in mind. So then the beneficiary must be individual members of the single family, charities, family entities, or other family fiduciary structures. So similarly can only manage assets of the single family and may not provide services to third parties. So any licensee with a single family office license are supposed to provide services to only one single family, not to many families. The next slide, please. What are the principal requirements? The principal requirements are that the liquid assets must exceed 10 million. So that means any unless there is a 10 family worth of 10 million is there, they will not be considered as a worthy enough to have a family office. So the 10 million is a minimum capital requirement for the family, which is supposed to have a family office. Then SFO must have an office in the DAFC. As per the DAFC norms, you are supposed to have your registered office in DAFC, and the licensing authority is Dubai Financial Services Authority, which is a regulator authority. That authority regulates these family offices. The next slide, please. Next slide, please. So ADGM. So unlike DAFC, the ADGM does not have a separate set of regulations for the family offices. So DFSC already has set out what are the regulations, as I said, 10 million and all those things. But whereas in ADGM, there are no certain restrictions or regulations provided by the ADGM, which is the regulatory authority of the ADGM. The ADGM has followed the United Kingdom regulations with regard to the establishment of the family office, and it's similar to what you follow in the UK. The regulations are similar to ADGM also. There is no single structure or regulation that encompasses a family office. While the structure available remain the same, emphasis is laid on the usage of ADGM ecosystem in order to complete various requirements of the family office. So that means they prefer you to use the ecosystem that is already existing within the ADGM, but it is not mandatory. There is no asset-based entry level criteria, whereas like in DAFC 10 million, there is no thing like this. However, common ancestry is obviously a prerequisite. That means you cannot operate or manage as a families of two distinct families, but you can manage a family having a common ancestry. That means you can manage the wealth of brothers, sisters, like that, but you cannot go to outside and manage their assets. So you can manage assets of one family at a time. Next slide, please. Restricted scope of these family offices or these companies. The is unique private. Apart from this family offices, we also have restricted scope companies. It's a special, unique private structure that can be the vehicle for choice of family offices. So you can have a license as a family office, or else you can also have a license as a restricted scope company. So that means charter of the company or else the license of the company will restrict its scope with regard to the activities, which can also act as a family office, and it does not require to maintain a physical office, protection from normal inspections of a company records and from the requirements of maintaining public records. Directors are required to prepare accounts, but not normally required to file such accounts and reports with the ADGM registered authority. Such accounts and records subject to public disclosure except exempt from audit and requirements except required under AML or OCS guide regulations. So this is also a similar single family office structure, but it is called a restricted scope of company. But the difference is that in a single family office, you will have more freedom, whereas in restricted scope of company, the freedom is a little bit slightly regulated or restricted. You have to keep that in mind. Next slide, please. So that's all from my side. So anybody wants to ask anything?
Thank you so much, Mr. Naveen, for your presentation. That was very insightful. So if anyone has any questions, you can drop them in the chat box, or you could also email it and we could get back as well. So anyone? Okay, looks like there are no questions, but like I said, in case there are any, please feel free to reach out to us. And this recording will also be available after the session right now. So it will be on the Asiajuris website. So you can feel free to check it out later. So thank you so much, everyone, for joining. This was really insightful. And I hope to see you all soon in the next webinar. So thank you once again.
Thank you very much for organizing. And thank you to speakers for participating and
Thank
sharing
you.
their know-how.
Thank you.
To speakers for participating and sharing
Thank
their know-how.
Thank you.
Thanks.